So we are waiting for more people to join in, Keshav.
We let them join as they come. For right now, we've started the YouTube live and the class has actually started. We just let them join as they come.
Okay.
So,
Okay.
very good evening and a very warm welcome to everyone. This is Vestralex free online community classes on law. This is your initiative by you, for you, and possible only through the generous contribution of our seniors, guides, mentors. And in that light, we have today, for the first time, I think, someone who is not directly a legal professional, but someone whose work is directly in tandem and directly correlated with the light of not
Keshav Savaj, the voice is gone, I believe. Dhananjay, are you able to hear him?
His voice is, we lost his voice.
Yeah, we lost his voice. We lost his voice.
so let अभी आ रही है थोड़ी सी आवाज मेरी
Yes, yes.
Yeah.
all right so Nirmesh ji, I request you to without wasting any time further I very warmly welcome you and I request you to kindly take this class forward. In the meanwhile, I'll work out what is happening, what is wrong with my system.
Okay, fine. We have around 19 people connected, including me and you also. So I believe we have audience out there. So hello, everyone. My name is Nirmesh, and I think because of the technical glitches that Keshav was having, he was not able to give a proper introduction and hand it over to me. So let me start by introducing myself. So I'm a certified data protection officer by Government of India, certified under Data Security Council of India, DSCI. And I'm also a member of DSCI, which is part of NESCOM. The initiative started by NESCOM, and I believe people know NESCOM, the technical body which deals with various things in India, is a bridge between the government and the corporates for all the technical policies and various projects which are launched by the government for businesses. So this is how I'm connected. And well, we are here to talk about DPDP law, Digital Personal Data Protection Law. Now, in the previous classes, if there are audiences who have been attending previous classes, I mean, this can be a bit different, wherein I am going to present some PPT because I feel that as soon as something, some text appears on your screen, it makes more sound in your mind. So let me know when my screen is visible to you. Somehow.
It's visible, Nirmesh. I'll also check my audio in the meanwhile by interaction.
Yeah, sure. Okay. Okay, guys. So the topic today is DPDP law, and I plan to talk about the role of lawyers and the role of IT engineers in implementing this DPDP law. But before I talk about the roles, it's important to talk about what DPDP law is all about. I understand not everyone in the audience understands the DPDP law, so we will go into a bit detail in the next 10 minutes about this law, and then we will move forward. But beyond this, today's agenda is this. We will first talk about the law. Then we will talk about how this law is meeting the compliances. Then we will talk about the role of lawyers and engineers. And then we talk about the privacy threats and the cyber attacks recently which have happened, and then the question answer round. That's the agenda. So let's talk about DPDP law. So as I stated, the full form of DPDP is Digital Personal Data Protection Law, and it was passed last year in August 2023. This law is actually making it mandatory for the Indian businesses to care about the personal data which they collect during the business routine work. Let me give you some examples. Like if you are a hospital, then you are collecting personal data of the patients. If you are an insurance company, then you are collecting the personal data of the people who are taking insurance and so on. So every business is collecting the personal data, and this law is applicable on all those businesses which are collecting the personal data. Uh, Now, before we move ahead, it is important to understand what is personal data. Personal data is any data which can identify you, and the exact jargon is personally identifiable information, PII data. So the PII data can be your name, can be your phone number, can be your Aadhaar detail, can be your bank details, can be your home address, can be your gender, um, can be anything which relates to you. And if two or three such types of data are able to identify you, then it comes under PII. For example, see, if I talk about gender only, you are a male, but then I'm not giving your name, your phone number, then you are not identifiable. But along with your gender, if in case your phone number also comes into picture or your name also comes into picture, and then these together form a PII data, personally identifiable information. So any data which is able to identify you is called PII data, or the personal data, and protection of this data is under this law, DPDP law. That's the crux or the gist of the law. Okay, and every business, as you can see on the screen, every business require a system which can manage consents. Now, what is a consent? We will talk in detail in the coming slides. But the dictionary meaning of consent is you accept for something which is for some your acceptance for some clause, for some rules. And here, when the personal data of you people is collected by businesses, then you give your consent and you allow the company to use your personal data. That's what the consent is all about. Then let's see what is there in the law. So the first thing that the law says is that whenever a business collects the personal data, it is important for them to give an itemized notice to the person. So a notification should be given to the person that your data is being collected, and this notice should be in a very plain language. So let me take an example. Let's say you are from a geolocation wherein you don't understand English, you understand Tamil because that is your native language. In that case, if you do not understand English and you know only Tamil, then the notice should be in Tamil language. That is mandatory under the law. Okay. So the notice has to be in the native language. That is the first condition. The second condition is that the jargon used in the notice, it should be plain and simple. Generally, the lawyers use an agreement wherein the words are something which are actually understandable by lawyers only and not by the common people. There are legal words. Now, the law says that in the notice which are sent to the people whose data you are collecting, you need to have a very simple and plain language when you are sending the notice. And this is a mandatory condition for the business which is collecting the data. We are calling Indian businesses as see, the law talks in terms of data fiduciary and data principal. So all those businesses which are collecting data, they are called data fiduciary, and those who are submitting their data are called data principal. So data principal and data fiduciary are two specific jargon used in the law itself. The law says that the language should be simple, but it's quite ironical that the law itself is using these jargons. They are not using simple words like Indian businesses or the submitter of the information. Rather, they are using data fiduciary and data principal. Next condition in the law, my screen. Is it okay? So the next condition in the law is that these businesses need to appoint a data protection officer, which is mandatory. So now every business which has a substantial turnover, and that substantial turnover is will be defined by data protection board. So let me inform you all that the data protection board for this particular law is going to come in couple of months. The law was passed last year in August, but the data protection board, which is going to release the policies which are going to govern the data protection compliances, is still to be constituted by the government. So the data protection board is still to be constituted by the government. It has to come into existence, and that data protection board is going to release at what turnover, at what value a business has this mandatory condition that the data protection officer is to be appointed. You can say a wild guess like 5 crore turnover or maybe 10 crore turnover can be the minimum range wherein it is mandatory for every business to appoint a data protection officer. It is synonymous to the way it happens in company law, the company law of 2013. Every business need to have a chartered accountant, a company secretary, and they need to do an ROC filing. So in a similar fashion, a data protection officer is to be appointed by every business, and this DPO has to file up the status of data protection in the company, maybe in a quarter or in a 6 months time. Now that duration, when I'm saying maybe, that exact figure will come up when the data protection board will come into existence, which is expected in 2025. The next condition and the mandatory condition in this law is that when the data is being collected, then you have to provide, I mean, the business has to provide certain rules, the terms and condition under which the data is being collected. And if in case there is any query by the person who is submitting his personal data, then the business has to respond within 7 days. If the response do not comes within 7 days, then the data principal, who is the person who is giving his personal data, that has the liberty to go to data protection board and register a complaint. So if within 7 days the business or the corporate do not give a reply to the data principal, then he can take next action against the business by registering in the putting up the issue in front of data protection board. The data protection board will be central. However, every state will be having a body which will report to data protection board. So locally, the states, within the states, the data principals will be able to put their complaints to the local authority. That is the gist of the DPDP law. I would like to hear from you all. Is this, I mean, you are getting it smoothly, and shall we proceed, or you have a query to talk about?
Yes, it's quite clear and nice. And please, I request you, because already I wasted some time in the start. So you please, we'll take a question and answer round towards the end of it.
Okay.
But for that also, Nirmesh, I request you to kindly just keep a tab on the time also.
Okay.
Thank you.
So I'm moving ahead. Okay. So how we implement this law? As I talked about consent, as I talked about that the personal data need to be protected, then then the execution requires certain softwares and tools which identify the personal information, and these softwares or these tools classify these personal information, they label them properly, and then the required protection action is taken for that particular data. That's how the protection of the data happens. So discover, classify, and label. Those are the 3 steps that technically these steps are taken within the business by the technical people using the software tools. Apart from classifying the data and protecting the data, the consents which are being taken are to be stored, to be kept, tracked, whose consent was taken at what time and for what duration. And moreover, when the consent is withdrawn by the data principal, then the data should be wiped out, cleaned from the mobile devices, from the servers. So those are the technical steps which need to be taken within the organization to become compliant for the DPDP law. And I tell you what, these are very high level steps that I'm talking about. There is huge number of things to be done beyond these also. For example, having a training office so that the employees can be trained is important for the businesses to create awareness within the employees on the data privacy and data protection. Then there has to be a proper data protection office with designated people out there. So there is much more beyond these 3 points for the execution. But yeah, to understand it at a very high level, these 3 things are important. Then comes how the lawyers are going to play a role in getting this law enforced, and at what point the computer engineers come and add value to the process, and how both lawyers and IT engineers can collaborate and make businesses compliant on DPDP law. On the left-hand side, you can see the various activities. There are legal compliances, there are data audits, there are trainings, there are an awareness, there are data breach response, data subject rights, policy developments, and many more. Now, how can I remove this particular thing? Okay, let this be in a corner. Okay, so a lawyer, he can understand the implication of this law, and therefore the lawyer has the responsibility to sorry okay so the lawyer has the responsibility to interpret the law correctly, inform about the implications to the corporates and the businesses, and help them in meeting the DPDP Act provisions. So forming the privacy policies is one thing in which the lawyers can contribute, the right policies which maintains the privacy for the data. There are various third-party contracts that the lawyers can create. Every corporate has tons of vendors and third parties. Now, those agreements with the third parties are generally non-disclosure agreement or generic agreement as far as this middle layer, the MSMEs, are concerned. However, the big corporates are quite cautious and alert and do make a very robust agreement. But it is important for these businesses to put data privacy clauses in the agreement, and lawyers can play a role, help them create these third-party contracts properly so that the data privacy plays a role into it. How can computer engineer help out here? Now, the computer engineer will put that software which can manage consent. So taking the consent online via the software, maintaining the consent, tracking the consent, which follows all the rights of data subject is something where the IT technical team comes into picture. For data audits, once again, the legal audits are to be taken care of by the lawyers, while the technical audits will be done by the IT engineers. Training and awareness, the lawyers can train employees on the legal front, and an IT engineer can train employees on the technical steps that they need to take while handling the personal data of their customers. So the training itself will require lawyer as well as IT engineers to collaborate. And similarly, there are various others. Data breach response. Now, data breach response is the point of time when the data breach has already happened, and the corrective actions need to be taken. Now, at this point of time, there are certain legal obligations because the data is lost. When the data is lost, lawyers are the best person who can understand what are the legal implications when the data is lost, and what corrective action on the legal front the company or the corporates should take to save themselves from the situation where they are in. an IT engineer will have to detect where the data breach happened. So the IT engineer is going to use the software tools, the tracking mechanism, the logs to find out at what point the data breaches has happened, and then how to plug that out so that in future such breaches may not happen. Data subject right now, data subject is a word which is actually coming from Europe in the GDPR. Now GDPR is a law in Europe which is similar to DPDP law. Rather, I should say the most of the 80% of the things in DPDP law are coming from GDPR itself, and GDPR is European Union data privacy law. So the word data subject is used in GDPR. However, in DPDP law, they use the word data principal. A data principal rights means the one who is submitting his data, somebody who is giving his data, his rights. He should be aware of his rights. He need to comply, not to give fake data. Has to give the correct data. If the data itself is wrongly given, the action can be taken against him. What IT engineer can do is the software which takes the data, that should have a security check so that it checks at the point where the phone number is asked, the right phone number is being given, and OTP should be sent to him. And if he responds to the, he puts the right OTP, then it is verified. So the phone number should be verified. In a similar fashion, other information can be Aadhaar verified. So all those checks and balance to understand that the right data is submitted is something to be put, the controls to be put by the IT engineer, while at the legal aspect, the lawyer can help that out. So that's how both collaborates, and both of them bring about enforcement of this particular law. So I think we talked about collaboration of law and technology. Let's take a use case. But before I go ahead with the use case, Keshav, is there a way we should be taking up questions, because we have already spent 30 minutes on this? And then we can discuss about a use case perhaps.
No, see, absolutely, we can discuss the questions. There are a lot of comments also actually which are being discussed. I am intrigued and interested. But only thing is, sir, that we have a limited time for today, right? And Q&A will definitely, because topic is also very interesting, Q&A may take extended time, which I am not very certain we'll be able to afford today. Also, just a disclaimer to everyone, simply because of the fact that I was not able to introduce either the class or your faculty today. Just the fact that Nirmesh ji is not a lawyer, right? So he's not an advocate, and this is not a class on the law. The class is on the understanding of the implementation of the law with respect to how lawyers, more so because this is a forum for lawyers only primarily, right? But we obviously anyone can benefit, but we're trying to understand how lawyers can explore the domain of what is there in the DPDP Act as to how that can be done, right? So I request everyone to try and understand the technical nuances. If you have a question with respect to a point of law, if you have a question, something like something which is very simple, for that I request, please take up the Bare Act. It's a very, very short act. खोलो, जो आपको डाउट है वो पढ़ लो, ठीक है? अगर थोड़ा सा कोई डाउट है, कोई आपको सेक्शन कुछ पूछना है या फिर किसी अथॉरिटी का आपको कुछ पूछना है, कहाँ कैसे बनेगी. But Nirmesh ji say, I would rather suggest to everyone that whatever your questions will be, try to line them in light of how, possibly in your career, in your practice, how you can possibly, expand the horizons by including whatever is there with respect to digital privacy and data protection of law. So Nirmesh ji will do a question and answer, short only towards. I request you also, because you also have a very specific and technical knowledge. So I want that technical knowledge should may come out, rather than exploring the concepts of law, because law, obviously, the law we cannot discuss in these circumstances and where we are right now. So I request you to kindly please take us forward.
Okay.
It's very Very insightful. I really appreciate आपने जिस तरीके से वो tables वगैरह बनाई है. And I request everyone kindly please just make notes. This is very important. This is the future. This law, please.
Okay, so I think for the time being, while Keshav was speaking, most of the people would have read these 2-3 lines which are appearing on the screen, the use case. We were about to talk about this use case. Let's take an example. In a company, some data breach happens, and it's a situation wherein the unauthorized access to the personal data has happened, and so this is a data breach. The company must respond promptly to mitigate the impact, because once the data is lost, there is huge impact, and it is important to mitigate this as soon as possible. Now, if such is the scenario where the attack has already happened and the data has been lost, what are the actions to be taken? And now in this situation, what is the role of a lawyer and what is the role of an IT engineer? Okay, so look at what IT engineer does. In this situation, it detects that the breach has happened. After detecting that the breach has happened, it identifies the scope. कितना ज़्यादा data loss हुआ है? What is the volume of the loss? Okay, and to what arena this loss is putting an impact. So technically, the IT engineer checks the volume, the size, the nature of the breach, and then accordingly, it informs the management. Then it implements immediate measures to contain the breach. See, the data has been lost, but the door from which the virus has come or door from which the hacker has come, if hacker is exploiting, let's not let him continue exploit. The door has to be closed. So the immediate closure of the door so that the hacker's access is immediately stopped. Whatever data they have stolen is already stolen, but they should not go ahead and further damage by crippling the system itself. So that blocking is something which is to be done by IT engineer. Okay, that is the role of IT engineer. And then comes the lawyer. Now, what lawyer is going to do is they will analyze the impact of the breach in context with the DPDP law. So when the DPDP law says that the personal data is to be protected, an IT engineer can tell how much data has been lost, but how much was the personal data? Okay, and if this much was the personal data which was lost or hacked, then is it going to impact globally, or is it going to impact Indian customer, or is it going to impact only a small portion of the business segment? Now the legal implication will depend on it. If it is impacting a small segment, then the legal implications will be lesser and can be manageable. So the lawyer may decide the legal application of the legal impact of the loss once the details of the losses are supplied by the IT engineer. And in a similar fashion, the lawyer can advise the company on who need to be notified and what actions need to be taken immediately. The DPDP law says that when the breach happens, they should inform the data protection board. And within 7 days, the businesses have to inform the data protection board, or else the data protection board is going to penalize. So the penalty itself is quite huge. The maximum limit of the penalty is 200 crores. However, the over maximum limit of the penalty in the DPDP law is 250 crores. In case you don't inform the data protection board within 7 days, then the maximum limit for the penalty is 200 crores. So you see, it's a huge penalty that is given in the DPDP law, and lawyer can try reducing it by taking the corrective actions in the time and communicate the same to the authorities. That's the use case that I have taken. And then there's a recent data breach that I wanted to talk about. If you would have heard, recently in 2023, Aadhaar data was leaked. Massive data breach has happened, and Now, when this happened, look at the right hand side, the impact, the personal data was exposed. The trust on Aadhaar got eroded. Um, the common public trust, as well as the businesses which are using the Aadhaar data, or the entities which are interacting with it, the trust erosion is something which is more impactful. There was a regulatory scrutiny, so the regulatory bodies took immediate action to rectify things. That was third impact, and then there was financial losses. If the personal data goes, then the financial loss do happen. Soon after this, government revised policies, and this breach happened in October last year, while in August the DPDP law was passed by Parliament. Soon after this breach happened, then our ministers Ashwini Vaishnav, he started talking about bringing up the data protection board very fast, and there were various steps taken by the government framing up the draft policies. However, those draft are yet not released. So that's one example that happened, and beyond this, there are many cyber attacks and data breaches happened. A couple of months back, 6 to 8 months back, AIMS had a data breach, and many other. So that was all from my side. Over to you, Keshav, from here on. And I'm open to the questions.
Yeah. Thank you so much. Thank you so much. Nirmesh, definitely insightful and definitely, how do I say, definitely something which will be very interesting for everyone to take and note from in this. Now, there are a lot of questions actually which we've received in the chat. So we'll take those questions up one after the other. So I request everyone to kindly take up your questions. Also, just one very humble request I have, that anyone who's wanting to ask a question, that kindly just make sure that your name is only reflected, right? So I saw that iPhone has raised their hand. So iPhone, it's unfortunate that we don't know who you are. Arey, Vinod sir is there. So first of all, guys, everyone, Vinod sir is here. Vinod sir, very warm welcome to you, sir.
Thank you.
And
So it was a very thought-provoking session. And I just wanted to ask one thing from the expert, that the data with regard to the hospitals, I would say that suppose a person has gone for a treatment and a doctor has given some opinion about that. So that opinion also becomes a data when we see the definition of the DPDP Act. That opinion also is a data. Isn't
Correct.
it, sir?
Correct. Absolutely correct.
So in case that is to be shared, suppose I am practically in one hospital and doctors are given an opinion and I am not in a stage to share that, incapacitated because of any reason, and the person who is looking after my health wants that data from that particular hospital and discuss that opinion with the third doctor.
Correct.
So how to deal such a situation, and whose permission has to be taken, how it has to, because the principal data owner again remain the patient as per
Right.
that. So how
Right.
to tackle that situation? That's my small question.
That's correct. So you are talking about attendant. Attendant has to pick up the data, and he want to consult somebody else, right?
Yeah.
That is the case.
Yes.
Now, see, the law says that the patient can take their data. However, there is also something called nomination, and that is part of law. There is something called right to nominate within DPDP law. It says that the data owner, which is data principal, has right to nominate somebody on his behalf to pick up the data, and it is very clearly defined, and it is also defined in the GDPR, the European Union law. Yeah, Vinodji.
No, I think maybe because I'm not clear. Suppose I'm incapacitated by virtue of anything, that I'm in a vegetable stage or that I'm put on a life support system, and the attendant wants to have another opinion about, and I'm not in a position to nominate anybody.
Okay, agree. So, see, at the time when the patient was admitted, the patient's details were submitted by the attendant. Now, if the patient details were submitted by attendant, then the consent was also given by attendant because patient was not in the situation to give consent for his data. In that situation, the attendant who is giving the consent becomes the owner of the data because the data is coming from him. No matter whether it do not belongs to him, it belongs to the immediate patient, but he signs the form, he gives consent. Okay, then the hospital is liable to share the information with the attendant itself. So I think right to nominate or nominating somebody will not come into question in this situation.
Thank you. Thank you very much.
Vinod sir, thank you so much. That was such a fantastic question, and I'm absolutely certain that there will be new horizons and contours of this law which will be explored, and I'm certain that you will be one of the persons who will be fundamental to exploring those.
Not like that.
One more thing can I add into it? See, this law is in India is applicable on healthcare as well as various other industries, and same is the case in Europe. But in US, there is something called HIPAA, and that is a privacy law which is applicable only on healthcare, on hospitals. And they are very clear about this situation which Vinodji is asking. Somebody who is submitting the data has the ownership of that particular data, and it can be shared by the hospital to him. Okay.
Thank you very much, sir. Thank you. Grateful.
Thank you so much, sir. All right, so we'll take the next question. So we have another question. So a lot of questions actually we have. We'll only take whatever we actually effectively can, right? And also, I'm just all right. So I'll just keep randomly asking because actually chat has become very extensive right now. So I'll ask the first question. This is there anyone else who wants to ask or raise their hands? So far, no. Okay. So there is this question from Mr. Neeraj Mittal. Neeraj, are you there? So Neeraj has a question. Neeraj Mittalji ka question. I will read Neeraj if you're not there as of right now. So it's so I'll just take the small question and then we'll come to these questions which are there by Amar Singh ji and a Cloud Tech ji. So it'll be better if you can just write your name, but okay, that's also fine. So Neeraj ji has asked the question, Nirmesh ji, what are its implications for IoT, AI, CYS, data science industries or students?
Okay, so IoT, Neeraj ji, when the IoT device provides any data, then initially one cannot understand what is there. I mean, the data is in such a form that it is not understandable. Okay, but then via use of softwares, via use of programs, it is filtered and some meaningful information is derived from it. When the meaningful information is derived from it, then it is stored somewhere. And if in case the meaningful information which you are deriving and you are storing in the databases or wherever you are storing, if it contains PII data, personally identifiable data, then the law is applicable on it. Now, this personally identifiable information, if you are picking up via IoT device, then law becomes applicable. You need to take consents, but there are very low chances of having PII data within it. If I take an example of these devices like refrigerators, your ceiling fans, they have an IoT device connected and they provide data, then there are low chances that you have PII data out there. But in contrary to these situations, there can be your other IoT devices which might be sending some PI data. So it all depends on the type of data. If the PI data exists, then DPDP law becomes applicable on it, and therefore one has to take consent. Now, after IoT, you are talking about artificial intelligence. So, see, artificial intelligence, AI, ChatGPT, and all these, they are already picking up data from the web, and and they are also picking up data which has IPs. I mean, if somebody owns the data and it is publicly available, then these models have already picked up the data. And a lot of debate is going on this. How can they pick up some data which is under some copyright? And there are various laws which are trying to address. A new law in Europe has come up on AI, and other countries are also taking note of it. But this is a field wherein still it is not very clear that can these models be sued. However, at certain places, certain decisions have been taken. So the things are not very clear. Can they be they can be pulled to a court, and they can be some allegations can be put on them accordingly. Then the next is your cybersecurity. Now, cybersecurity, well, once again, see, the whole story comes about PII data. If the data which is under scope is PII data, whether it is cybersecurity or your data science or your IoT or AI, then the law becomes applicable, and all the terms and conditions need to be followed. So further analysis is required in all these fields, Neeraj, which you are asking, to understand whether the PI data is in scope or not, and then it can be termed whether some implication will come on it or not.
Certainly. Actually, I'm very excited to see just one aspect of this that I see. Vinod sir, if you're still here, I would really request your kind comment on this also. That I see that there is a lot of litigation which is going to come forward after this. How income tax matters are that there's a lot of classification of various heads and titles of incomes and all. So it's a general discussion, I think, for everyone to keep in mind. But I see that because all this PI data and all, there'll be a lot of litigation will definitely be there a lot with respect to this law. So anyways, we'll come to the next question. All right. So Amar Singh ji has a question. Amar Singh ji, let's take your question first, please.
Hello.
Yeah, hi, Amar ji.
Hello. Good evening, sir.
Good evening.
Sir, I have a question regarding the intimation of the notice to the individual whose personal data has been seized if under the DPD Act. According to GDPR, the affected person notifies after they reviewing the data using software like famous software like Relativity. So my question is, what is the DPDP Act in this regard? If they mention any software or any other tool to
Your voice is not very clear.
the data.
He's basically asking, is there any software or tool with respect to how GDPR compliance, you have some software and tools which can help? So are there any software and tools?
Yes, there are software and tools. If you look at the internet, OneTrust is one of the biggest company you have in European domain. They have several customers, and globally they have customers. And OneTrust has its own products which helps in meeting GDPR. And they also claim that they help in meeting DPDP law. And as I said, that there are many things which are same in both GDPR as well as DPDP. So these big companies like OneTrust just need to do some customization, and their product can be fit for DPDP law, which they have already done. They are claiming so. Apart from OneTrust, there are many other companies who also say that they have products for this DPDP law. FRS Lab in India is one such company, and then all the big guns like HCL, Wipro, they are also coming up with their own product on the DPDP law. So yes, there are products. That was the question. Am I able to nail the question rightly?
Yes, sir. Yes, sir. Thank you. Thank you so much.
Thank you so much. Thank you so much. And Amar, thank you so much for that question. It was actually very, very relevant and very essential also. So there is this question from AA Cloud Tech Private Limited, right? So it's interesting to see a company being represented here. So AA Cloud Tech ji, who is representing you?
Thank you so much. Yeah, my name is Utkarsa, and I'm a founder of a company. where we develop, multiple tech products. And in that
Wonderful.
sense, yeah. So my thing is that obviously I hire external consulting, tech teams. So that is maybe they're under contract for about 5 to 10 years. So my question is, in such case, when the data breach happens, and while I'm the parent company who's designed and whose platform it is, but the entire tech is given to an external team. So in case some data breach happens in that case, do I need to first ensure that my NDA or my whatever contract with them is watertight, where I mentioned that they are to be liable for any such breach? So because we're talking about some 250 crores that can, are fine. So is that something I can put into my contract while I'm doing this kind of, what is it, collaboration with external partners?
What your
Let me,
question is, it's quite relevant, and I see that that's not on the engineering part, that's more on the legal part of it, because now you're seeking what exactly would be the implication of this new law on the existing contracts and with respect to the provisions which can be added into contracts in the future, right? If I'm understanding
Yes,
correctly, that is
yes, yes.
your question is primarily.
so see, what I understood is you are collecting the data and sorry, somebody else is collecting the data on your behalf. So you have outsourced something to some technical company, and they are collecting the data, and but the data is owned by you. Is that the right understanding I'm getting?
Yes, sir. The data, I mean,
Okay.
yes, the platform is owned by me, but the
Okay.
tech is external, a consulting
Understood.
part.
Understood. Okay. So platform is owned by you. Technology belongs to some other company. I mean, some other company is taking care of the technology. Your platform is collecting the data. So in this case, you become a data fiduciary. Data fiduciary is the person who owns the data and who is responsible for the data and who has to ensure that data should not get breached. The the company which is taking care of the technology on your platform, they become a data processor, because initially in their technology the data comes, the step one of the data is in their technology, and then it is processed, and then perhaps it is further used, whatever the case may be. So they become data processor and you become data fiduciary. So what law says is that data fiduciary is responsible for the data, and data fiduciary has to ensure that data processor is following all the norms of DPDP Act, and um, the data processor with data processor you need to have a very tight agreement um, on not only the non-disclosure but maintaining the privacy of the data. So agreement is not the only thing which is sufficient for you to be a DPDP compliant. You have to move ahead and ask your data processor or that technology company, are you DPDP compliant? If you are, then please submit the audit report which shows that you are DPDP compliant. So that type of step will be required on your behalf, and that might come up once the data protection board comes into existence and the rules and policies are enforced. So a lot will come into coming months, and then it is very clear that how you can ensure that these companies who are giving you service follow the norms and are compliant. But since you are the owner of the data, the responsibilities lies with you, and that particular company is not totally free of the responsibility. If they are collecting the data, being a data processor, they also have certain level of responsibilities for which they become accountable. So more details, I think once the data protection board comes, then it will be possible.
Thank you so much, sir.
Thank you so much. So again, for everyone, I think this is a gentle reminder only that this is a very nascent law, and at this stage, practically, I would say that there's absolutely a lot which is going to change, no matter what happens. And very few people have read the law, so to say, and whatever implications are there, they will definitely come into picture in slow, eventually and gradually. But it's a wonderful thing that people like Nirmesh ji are already on this app, on this at least on the compliance bit of it, so that it can execution can be done as and when things move forward in that respect. Similarly, it's also been wonderful, Nirmeshji, to learn from you today that all of these companies which you mentioned are already providing some kind of solutions and softwares for everyone. And similarly, it's a very fundamental and very important aspect of using technology today, because I see that when we have registrations, we also have our own forms, and obviously we have the consent and all of these things, which we've been doing for whatever time we've been doing it now, much before the law came into picture. But now at least we know that moving forward, things are going to be taken more seriously, and more at least the data of people will be respected, hopefully. And for that, Nirmesh, we'll definitely look forward to more from you on how the compliances are effectively taking place, also probably sometime in the future. So it's been really wonderful, very enlightening, very insightful, and that PowerPoint presentation of yours, I'm absolutely sure that anyone who's had the occasion of going through it would probably want to sit down, take notes as well. So I think just one final question from Mr. Pranav Durve, since he's raised his hand. Pranav ji, आपका क्या सवाल है, प्लीज एक बार आप पूछ लीजिए.
Thanks a lot. Thank you very much. Nirmesh ji, my question to you is quite simple. Basically, I have a startup. I'm a co-founder of a startup, and we have a product which is a personal identification kit for emergencies, typically used in the time of accidents. So when there is an accidental situation, people helping out, so what we use is a QR code based technology, a sticker. So in case if there is an accident which happens and people helping out, all they have to do is scan it, and they get the basic information of the person: name, age, blood group, and existing health conditions. As well as then, it triggers a emergency alert to their emergency contacts and all that. So we are collecting information which is basically blood group, existing health condition, which the person who's registering with us is the one who's putting that information. So somebody is diabetic, somebody is maybe allergic to penicillin, or somebody who's maybe having a low BP or a high BP problem. My point, the question that I want to ask is, we are an ABA certified member. Is that sufficient, or we need to actually go for a DPDP compliance completely?
Well, DPDP compliance has to happen. I don't think any other certification can work. But once again, unless the DPDP board comes into existence, it will be hard to say that what norms they are going to put up. I personally believe that they will not end up with some other certification and might ask for. But let's wait. We cannot comment unless the rules comes in place.
Absolutely. So in that respect, and this is something, Pranavji, not just in answer to your question, but to everyone who's been referring to this video, I want you to just know one thing, that as of right now, this particular session has been highlighting the technical aspects, how the relationship between both the legal aspect of the compliance, because lawyers are not engineers, lawyers are not computer, developers, software coders, etc. So lawyers will always stick to the point of law. Whatever your questions are, whatever your doubts are, always with respect to any kind of point of law, I will always suggest that have a very thorough compliance of all, because, and frankly, if you're having an organization, you will have just get your legal things sorted with respect to any kind of update that you want to have with your this thing. And obviously you'll have people like Nirmesh who will suggest you that where and how much exactly would that be required. But in that case, Nirmesh, I think your contact details are also there in that presentation, so I'll request everyone to kindly refer to that presentation very strictly as per whatever, and obviously just just verify and cross check whatever is there if you have some sort of doubts.
Sure. Thank you very much. Thanks a lot.
So with that, thank you so much, Nirmesh ji, आपकी इस wonderful session के लिए. And at the same time, I would also like to take इसको आप बंद कर सकते हैं स्क्रीन शेयरिंग को अपनी. I would also like to most humbly request and invite Shri Om Prakash Ilanti sir, who's there. And Om Prakash sir, first of all, very warm welcome to you, sir.
Good evening.
And so it's just fantastic, sir. It's always so wonderful to have this opportunity and occasion to learn from you. So we were having this discussion on the DPDP, the Digital Data Privacy and Protection Act, which is recently been enacted, and we had the good fortune of having a session being conducted by Nirmesh ji in this respect. Sir, any sir parting thoughts for his session, sir, since we'll be starting your session shortly, and we'll also get to get your insights and ideas on this. So just a brief introduction to everyone who's with us right now. Om Prakash sir is a leading civil lawyer, and he's an exceptional lawyer with respect to company law. So any of your doubts or anything that you have, with respect to this, not with respect to the digital data privacy protection, but primarily with respect to any kind of privacy and all. So just your views, sir. What are your views with respect to the advent of privacy in the data and digital sphere?
You ask me, Keshav?
Yes, sir. Yes, I am asking you, sir.
Okay.
That
Now,
these people are.
it is in a kind of a nascent stage, but an essential law which is developing very well. See, there is a requirement of this protection in terms of various international conventions, as well as if you go back to our own system, we have got so many guarantees, and one of that would be to protect our own self. And this technology which has developed in a big way, and technology which is taking us to different stages now, requires certain kinds of protections which are there, and which has to be assured by all the platforms. So in that context, this is very interesting law which is developing. And what I feel is that we have a long way to in fact go.
Certainly, sir. Certainly. Thank you so much. So, as a matter of fact, it was a very interesting session. I just could make one thing out for sure, that there will be definitely endless litigation possibilities in this.
Yes.
So, I'm hopeful all lawyers will get to benefit from that also. And obviously, people, that it may be beneficial for them as well. So, Nirmesh ji, thank you so much आपके वक्त के लिए, and thank you so much for sharing this wonderful presentation with us. I'm certain with the number of questions that we've received today that this is actually the need of the hour, and there's a lot of questions I could see. So we're very excited for you, and thank you so much to you, Nirmesh ji. You're on mute, Nirmesh ji, actually.
Thank you. Bye-bye.
All right. So thank you so much, and we'll conclude this class. So guys, any other questions? Please, you have Nirmesh ji's details. Just reach out to him if you want. If you have anything else, तो फिर यहाँ पे जो भी आप वीडियो भी देख रहे होंगे उसके अंदर just put your questions over there. We'll see, and if there is some possibility, we'll try to help you also. All right. So thank you so much. Thank you so much. And now we'll end this class.